excited to have Lori Levy and David Jones, two of the top legal professionals in Texas Realtors, with us today. We are discussing the proposed NAR settlement and new forms that have come out from Texas Realtors. Lori, David, thank you so much for joining us today. I want to remind those watching that this is being recorded and to put your questions in the chat, and we will do our best to get to them. Let's just get right to it. Same question for both of you. How long have you been with TR and how did you get started? Lori, let's start with you.
Thank you, Sterling. Thanks so much for having us. I am Lori Levy, General Counsel at Texas Realtors. I have been here almost 19 years, going on 18 and a half this month. Came over here from the Texas Capitol, spent 10 years there after law school, and came over here and been here ever since.
And I'm David Jones. Is microphone working okay?
Yeah, we hear you good.
All right. Hey, everybody. David Jones, Deputy General Counsel here with Texas Realtors. I've been with Texas Realtors just over 8 years, and I wear a bunch of different hats. We, obviously work on the contracts. I deal with our professional standards department, the legal hotline. So it's kind of all over the place, but glad to be here.
Awesome. First thing in the chat, I can't hear. We were having a little bit of technical difficulties right before we logged on, so yep, we got no volume. Click volume. No, thank y'all both. I know y'all have a busy schedule, and y'all, how many forms classes have y'all done collectively?
That's a hard number to pinpoint. I think we're each doing 1 to 2 a day, 5 days a week. But it's been great to do them online. We can reach a lot of people that way.
Yeah,
absolutely. Meagan?
So let's start, Lori and David, just kind of a background. How did we end up kind of where we are today? What started this and what caused Texas Realtors to realize we needed to change our forms a little bit?
I'll start. David, feel free to jump in if I say anything wrong. That's the great thing about presenting with a coworker, right? I'm going to start in the middle, though, with the settlement. NAR announced a settlement in the Sister Burnett lawsuit on March 15th, and that kind of changed everything. We had been sued in a copycat suit here at Texas Realtors, along with local associations and brokerages here in Texas and our MLSs. And so with the settlement, we went from defending ourselves in a lawsuit to getting into change mode. What did we need to do to comply with the terms of the settlement? The settlement is not final yet. It has been preliminarily approved by the court, and there is a date at the end of November when the court will hear testimony regarding approval of that. So we're looking forward to that at the end of the year. But the terms of the settlement agreement did require NAR and the realtor-owned MLSs to make changes in anticipation of getting that final approval. So in May, we were all in Washington, D.C. for the NAR meeting where they adopted changes to the mandated MLS rules. Those rules did necessitate changes to many of our Texas Realtors forms, and so that's what we've done.
Great.
And the best thing is I feel like Texas was a little bit ahead of the curve already. What are you hearing, if anything, about other states and other associations like having either issues or non-issues? I mean, are there anyone having trouble that you know of?
Well, I think, Texas was one of the early adopters as far as our forms go. We wanted to put our forms out early because, our forms came out June 24th. And we want to give our members some time to work with them, figure them out, learn, you used to put something in this paragraph and now you got to put it in this paragraph over here. And we wanted to give our members time to actually work with them, not just looking at them on the screen, but actually working with them and having to fill them out long before the deadline for the change. So the deadline for the change, August 17th. And so we put ours almost, 2 months ahead of time. I think we were one of, or if not the first association to actually put out the new forms. California, you may have heard in the news, they were going to put theirs out like the Friday before ours came out. We were putting ours out on Monday. They were planning to put theirs out on the Friday before. And then they got a nice little love letter from the Department of Justice. And so, with that letter, it's a CID, and they had some questions about their California's forms and their version of what they changed because of the settlement. And so California made a difficult decision to pull it back at the last minute. And then they reviewed theirs, and then they just recently reissued them after they kind of reworked theirs. But as far as I know, I haven't heard of the DOJ, doing that to anybody else. Texas Realtor certainly has not heard from the DOJ, but we're confident that our forms are in full compliance of the settlement and are fully transparent and provide the consumer choice that our members need.
I'm so glad you spoke about California, because I've been keeping up with that for some reason. I'm fascinated by it. And so I've read their forms, and it's made my head spin a little bit, and kept up with everything going on over there. So, that's one thing. So we focus so much on Texas. This is happening nationwide. And that's something to think about, because one thing I've heard from a lot of people is, well, we've been doing this forever here in Texas. Well, not every state had buyer representation agreements. Not every state had what we have, thanks to Texas Realtors. And so that's why, it's kind of hard to make a national settlement agreement for each state. It's hard sometimes. So one of the questions in chat is there a good website page? Facts.realtor is the best place to go right now for the NAR updates. They post as soon as they get them. I'll put that in the chat so you have that.
We also have a page dedicated to the settlement, texasrealestate.com/lawsuit. We are transforming that into a training page where we've got videos. We started recording some very short informal videos just on kind of the top questions we're getting on forms. And we're putting FAQs there as well, not only about the settlement and the implications of it, but actually how to use the forms. I think a lot of agents are going to need to rethink how they talk to their clients and how these forms will be utilized in that discussion. So trying to put as much information out there as possible, along with the hundreds of classes that we know are being offered.
Lori, what's the number one question you're getting?
Oh, that's a good question, Sterling. Really, it's about the practice, how the practice is changing. We were concerned, with anytime you change a form, there can be confusion, a little bit of a learning curve on the forms, but it's really agents trying to understand, okay, what does this mean for how I operate in a transaction, how I get paid, how I talk about that with my clients. So trying to help brokers train their agents on those conversations that need to change to provide that additional transparency. That's kind of the number one question. They're kind of using our forms. They call our legal hotline. We do have a member benefits service, the legal hotline for our members to call. And we are getting questions daily on this. But a lot of times, I think the number one issue is, oh, okay, my practice is going to change now. How do I want to make that happen?
Yeah, we've seen that a lot too. Some of these questions are best practices and policies within a brokerage, not necessarily, usage of the form. But I was just curious. I mean, of all of the frequently asked questions, what was the first?
On the forms themselves, I think the differences in our listing agreement on cooperative compensation. Mm-hmm. We still allow a seller to choose to allow their listing broker to offer compensation. And that's kind of where the practice comes in. Our member understands that, and then they have to kind of think about, well, how am I going to do that? I'm not doing that in the MLS anymore. Am I going to do that on my website? Or they're asking us, under the settlement agreement, can I do that on my website? Things like that. So that change in the form about sharing compensation, or if the seller does not want to allow the listing broker to offer compensation, what are the other ways that a buyer's broker will be able to get paid?
Yeah, I would say the other big question that we get is with the written buyer agreement requirement. We get tons of questions. NAR has always push for use of written buyer agreements. Texas Realtors has a great buyer rep agreement. And we have also said, we're attorneys, so obviously we're going to say you should always use an agreement that really spells out the rights, remedies, obligations between you and your client, so there's no misunderstanding. So I think use of a written agreement with your clients is a good thing. But now we've got this mandated rule as part of the new MLS rules. It's, well, if you're working with the buyer, you got to use agreement. So what are the scenarios like open houses? And so we get a ton of questions about the written agreement requirement.
Yeah, we're going to get into some of the forms a little bit later, on specifics. Let's go back to the website rule real quick. Okay, so my personal website has an IDX feed from our local association. But because it has an IDX feed, am I or am I not allowed to have manually put in my own listings from the backside and offer compensation? But with knowing that I do have an IDX somewhere on the site.
You are allowed to put compensation on your website, even if you have IDX feed, as long as it's only for your own listings. You would not be able to aggregate other brokers' listings, but you can, on your own website, your own listings, yes, you can put offers of compensation up there, even though you are still using an IDX feed. That is a specific carve out in the settlement.
Okay.
One question that came up in the chat that I've heard a lot is, when are TREC forms changing? So we're talking about Texas Realtor forms. Do y'all want to speak on that a little bit?
Yeah, I'd be happy to. We have been communicating with the Texas Real Estate Commission, TREC. And I say it that way because a lot of folks get confused between Texas Realtors and the Real Estate Commission. So the Texas Realtors forms are published. They are being utilized right now. TREC does have a broker lawyer committee. That's the committee that proposes forms to the commission for their adoption. They have to follow some specific procedures to update their forms, and so it takes a lot longer. If TREC does update their forms, it will likely be the end of the year or the beginning of 2025 before they're out for use. That committee has been meeting. They did establish a subcommittee to consider the specific practice changes that were coming along with the new MLS rules. And they have work underway. They may be proposing forms in August. And once that happens, those forms have to go out for public comment. So at that time, we'll be reviewing the forms. We'll be encouraging our members to do so and to send in comments to TREC on that. And then they would adopt them at the earliest in November. So it's a long haul for them to get forms updated, but they're in that process.
Great.
Perfect. So I guess let's touch on open house, because I mean it's a hot topic. So scenario one, you are holding your own listing open. You represent the seller, you have a listing agreement signed, et cetera, et cetera. Is it good practice to have the representation disclosure, a stack of them signed that says, I, Sterling, represent the seller?
I mean, you certainly can. It is one of the forms we have available. And I did see a couple questions in there in the chat. And just to confirm that, if you're the listing broker and you're holding an open house, you represent the seller. You do not have to get a written agreement signed with every buyer that walks in. Okay. That requirement is if you are working with the buyer, which essentially means that if you are representing the buyer's interests. As the listing broker, you represent the seller. You have every right, authority to provide access and open up the property as part of your representation with the seller. So no written agreement is necessary. But then that issue does come up. What happens if you have an unrepresented buyer walk in and you want to make sure that there's no misunderstanding about who you represent? We do have a form for that called the representation disclosure. It's number 1412. We've had that form for a while. That was originally part of, there is a statute in the Occupations Code, Texas Occupation Code, otherwise known as the Real Estate License Act, that requires license holders to, disclose who you represent your first meeting with the other party. You can do it in writing, but you could also do it verbally. So you've all been doing it, anyways, when you call somebody up and say, hey, I'm the listing broker, my name's David Jones, I have a buyer, you've been complying with that. But some members wanted that documentation in writing. So that's what the form was originally used for. I'm sorry, 1417, not 1412. That's what that form was for. And so because of this issue and because of the open house issues, we kind of beefed it up, and we not only said, this is who I represent, but we put an acknowledgement that, and I'm not representing you. So that way, if a listing broker does have people coming in and they want to make sure there's no implied agency created, that unrepresented buyer knows full well that you are not representing them, we put some additional language in there so that, that it would be good to use in that scenario for listing brokers to say, hey, here you go. Here's who I represent.
Okay. Second scenario, Meagan and I are under the same brokerage, hypothetically, and I'm going out of town. I have a really nice listing. She wants to hold it open. Same brokerage.
If you're in the same brokerage, then you are still representing the seller. And it's interesting that these questions do come up. Sterling, we've gotten that question a lot, and this is opening up some issues where we are realizing a lot of our members didn't understand certain concepts in agency as well, because it didn't come into the discussion. We didn't have to talk about these things. But now that written representation agreements are required before an agent can show a buyer a home, the issue of who does not have to have that written representation agreement. So we first talked about the listing agent holding the open house. And now this question is another agent in that same firm. That's still the broker's listing. So any sponsored sales agent of that broker can hold that open house and follow what you and David were just talking about.
Okay, but if you have an unrepresented buyer that comes in, is that creating sub-agency?
Not if you are a sponsored sales agent of the firm that has that listing.
Gotcha.
It is the same scenario as if you are the listing agent.
Perfect. And then the third scenario, and we don't see it much here, but I guess in metro areas, you'll have other agents from other brokerages call and want to hold your house open. Again, what?
So in the metro areas, what we're hearing is there are actually showing apps. There are companies out there that have created these apps on your phone where I guess either you are looking to hold an open house for somebody else, or you're looking for someone to hold an open house for you. If the agent holding the open house is not an agent in the listing firm, so you're under a completely different broker, it gets a little bit confusing. So let's talk about it for a minute. The issue of sub-agency versus do you need a written representation agreement with buyers that come to that open house? We have always said that a sub-agent is working on behalf of the seller. But just because you're not representing the buyer, that doesn't automatically make you a sub-agent. You have to have the authorization of that listing broker. And there is confusion now because people are saying, well, under the app, I do have authorization. But we want agents to think about, why are you holding that open house? Are you really working on behalf of that seller? Or are you offering to hold that open house as an agent outside that listing firm so that you can meet potential buyers? We think that in those scenarios, you do need to have a written agreement with the buyers that come through that door.
Yeah, and I would just think it boils down to representation. Whose interest are you representing? Sub-agency is not just a word. You can't just say, oh, I'm a sub-agent, therefore I don't need a buyer representation agreement. It's okay, well, if you're a sub-agent, that means you represent the interests of the seller. Are you really conducting yourself at that open house with the seller's best interests in mind? That's probably not why an agent from other brokerage is holding that open house. Like Lori said, you're trying to meet buyers and get a potential client. you're not a sub-agent under that scenario. You're under the terms of the NAR settlement, you are working with all of these potential buyers. So you would have to get written agreements for that scenario.
A similar scenario is an agent that has a relationship with a builder. And so perhaps they list that builder's homes regularly, but there are homes of the builders that are not listed, and the agent wants to to have an open house for a home that's not even listed on the market. Again, without a representation agreement with that builder, without a listing agreement, home's not even listed, what is your purpose in holding that new home open? Whose interest are you trying to represent there?
And one thing I want to say too about this is you need to make sure what your broker's policies and procedures say. Because I'm a broker owner, my policies and procedures don't allow agents from outside my brokerage to hold open houses, and don't allow my agents to hold open houses outside of our brokerage. So make sure you're in communication with your broker to know what those policies are, so you don't get yourself into a even worse, potentially worse situation.
So Anne asks, so open houses being held by any agent other than the listing brokerage agents is dead, because how many buyers are going to sign a buyer rep agreement at an open house?
We do have a new form that might assist with that. We have long had a buyer's representation agreement. We have encouraged members to use a written buyer's representation agreement in their practice for many years, as long as I've been here. We have now adopted a one-page buyer's representation agreement that may assist in that effort. Under this representation agreement, it can be for full services, just like our longer version. But we also have an option in there, a checkbox for showing services only. And so that might be an opportunity for agents that are not with the listing firm to be able to hold an open house and be in compliance with the MLS rules. Good
point. You touched on the builders. One question we had come up was, certain builders like to use their own builder contracts. And so if you have a builder contract versus a TR contract, are there any additional forms you foresee us needing if you are utilizing a different industry's promulgated form?
I mean, that's difficult to answer because, we're not familiar with all the various forms out there. So we don't know how they would work, like in conjunction with, like we have addendum specifically that reference, track contracts, the 1-to-4 contract. So if you've got a builder contract, then the provisions that, are being amended or changed are, they're not going to match. So it's kind of hard to really answer that because we don't know all the various builder contracts. I mean, I would say if you're not familiar with the contract, it's like, you get training on TREC contracts. You get a lot of training on Texas Realtors contracts. So like this here. So you're familiar with the provisions. So now if somebody else, if the builder is throwing a contract at you, that's when you want to advise your client. You might want to, have an attorney look this thing over because you certainly don't want to practice, unauthorized practice of law.
Perfect. And kind of segueing off of that, I know when 8.0 came out, there were certain property types that were exempt. Are there any exemptions to the buyer rep requirement?
The written buyer representation agreement is you have to get the written agreement with the buyer when you're working with the buyer before touring a home. And a home is defined as a 1-to-4 family residential property. So if you are showing vacant land or vacant lot, you're not required under these new rules to get a written agreement, or if it's a commercial property, you're not required to get one. The interesting category is the farm and ranch, because farm and ranch, that is not that's a separate category for Texas, but that's not really a separate category for this settlement. So it's a 1-to-4 family residential property. So if you got 200 acres and there's a house on it, that's a single family property. So you would need a written agreement to show that property.
Yeah, you said that in one of the Candy Cooks classes, and my head almost exploded. But okay, so barn dominiums, we see those a lot here in Texas, where you have a metal building with a small apartment finished out, with the remainder being warehouse space or whatever. Because a single family can live there, we need to go ahead and have it signed. Is that accurate?
I mean, I would say, to take the conservative approach, I would say yes. Yeah. Because, as Lori mentioned in the beginning, we are still under preliminary approval here. We have not got final approval of the settlement from the judge, and we still have, the DOJ is still keeping a very close eye on the real estate industry. And they've just come out and said, okay, we know you got the settlement, but we're watching. We're watching for workarounds. We're watching to see if these settlements really does have an impact and change the industry. So I think, at this point, I would always take a conservative approach and say, yeah, because what are we talking about? Getting a written agreement signed with your client. That's not a bad thing. We're not making you do a bad thing. It's getting a written agreement signed with your buyer before you go out. And because, we have the different agreements. We've got the long form 5-pager. We've got the short form. You can do full services. You can do the short form. You can do the showing services, as Lori mentioned. And we put a lot of flexibility in that document. For example, in the short form, there's a spot for the market area, like how big of an area. It can be, a size, but it can be a county, but it can also be one single property address. And the term, how long is that agreement going to last? It could be 1 day, right? And then you can check showing services. This is all we're agreeing to. I'm going to open up the door for you. And then the fee, we have FAQs. Some have said, well, can we put 0 in there? Yeah, you can. Okay. That's not that big of a hurdle that you got to jump over. One property, 1 day for no fee. That you can do that and still comply with the get a written agreement signed.
How much of this do you think is just people being uncomfortable with change? The not wanting to have that conversation with buyers.
I mean, I think change is, there's always going to be people uncomfortable with that, but I also think it's that they haven't taken these classes yet. They haven't been educated yet. They don't know what it looks like yet. So the more that we can do these types of programs to get the word out, people feel better, especially once they see the updated forms. Oh, okay, this is how it's going to work. I also want to point out that your question earlier with builder contracts, and there's a question in the chat about farm and ranch, even if it's going on a farm and ranch contract. Remember, what the updated MLS rules under the settlement agreement deal with is representation. Most of the forms that we created or updated only deal with the agreement between a client and their broker. And so this rule applies to that 1 to 4 family home on a farm and ranch property, but for purposes of which form you use, you're still going to use that farm and ranch contract. So I think there is some confusion out there about how this applies, and it applies to that relationship between clients and customers and the MLS participants, the real estate agents.
I'm seeing a lot of questions in the chat about
Perfect.
compensation. Can we pivot and talk about that a little bit? Because compensation cannot be listed in the MLS anywhere. It can't be in agent remarks. It can't be in attachment. It cannot be anywhere in the MLS. So you said earlier, we can put it on a website as long as it's separate from the IDX feed for our personal listings that our brokerage has. Are there other ways to communicate that to other brokerages?
So I used to make the joke that we're all going to go get our fax machines down out of the closet so that we can talk to each other again the way that agents used to. back in the day, a very long time ago. I mean, this is one of those questions that gets into business practice, not so much our forms. Um, Brokers are coming up with ways to communicate with each other about that. I think I saw a question in the chat about putting a rider on a for sale sign in a yard. That is allowed. The issue here is the MLS funneling the properties where you're putting your offers of compensation? It has to be completely separate and apart from the MLS. And so the answer is yes to the yard sign. We're getting this question a lot about different places that it can be put, and we're happy to consider those. But we're all working through the innovation that our members will come up with to ensure that it would be in compliance.
But we all, I think, maybe speak against trying to put something in photos in MLS that's a workaround, or specific wording in your description. Let's not find workarounds. Let's find ways to work within the law and make it, make it easy for everyone.
That's exactly what we've been saying. I heard the story of a broker that wanted to stitch their offer compensation on a pillow.
Yes.
And it was going to be in the main bedroom, and it's a workaround. It's the right word. And we want to stay away from that.
Perfect.
So, as far as the writers go, it's not smart to put an actual percentage, right? Are there terms that TR recognizes as, realtor friendly or buyer comp available, anything like that? I mean, I guess if you wanted to, you could put a percentage, but you're printing out one sign, one rider, and it could change for your next listing. I mean, what are your thoughts?
That's a conversation to have, with the client, exactly what type of marketing, do you want to do? It's not against the rules to talk about a percentage, as long as it's outside of the MLS, and as long as wherever you're putting it is not using MLS data. So if you've got like email blasts that you can put on your website, we already talked about the sign writer. There are so many, ways. Realtors are entrepreneurs. You've got that spirit, that creativity. Instead of using the creativity to come up with workarounds, use that creativity to come up with okay, how am I going to thrive under these new rules? There's always going to be change, and there's going to continue to be change. 10, 15 years from now, there might be some other big issue and we need to change a bunch of stuff. There's always going to be change, and now's the time to really to exercise that creativity and come up with, a lot of these are broker policies and their procedures and and their marketing ideas. I've heard a lot of, some ideas from members that thought that sounds like a pretty good idea. That's interesting. I've heard, use of QR codes that, you can put on a sign, and that's going to lead you to their website where the offer of compensation is. So, I think it is a little bit, it's new, and there's a lot of questions, and sometimes there might not be an immediate answer to those questions. And so, people are freaking out. I think people are going to do what they always do. They're going to come up with answers, and months from now, it's going to be like, oh yeah, this is what we do. And it seems like a bigger problem now than it's going to actually be.
Agreed.
I would add to that, there's new language in our written agreements that's required by the settlement that broker commissions are not set by law and are fully negotiable. So we did add that to our agreements. But there's another phrase that we're adding as well, that brokers set their fees independently. So nothing in this stops a broker from determining how they want to set their fees and how they want to advertise that. The issue is working with competitors, with other brokers, and how you're going to do that. So we want, as David talked about, the entrepreneurs in the field to come up with these ways. As brokers, they can have their sponsored sales agents advertise a certain amount in a certain way. Brokers should feel free and independent to come up with their ideas and run with those, ensuring that they're in compliance. But brokers can still and do set their fees, their commission, their compensation independently.
Well, and I
So
think we're
let's-
just going to have to get used to answering our phone a little bit more. And just remember, you know, we are agents. We do like talking to people. We're not appraisers who don't like talking to people. Get that jab in, because Sterling's an appraiser also. I have to do my appraiser jab. But just answer your phone, I think, is going to solve a lot of these problems.
So let's flip it and talk about the buyer rep and the percentage in that conversation. You know, I know a lot of people are, how do we get a workaround on this? How do, you know, I don't want to ask my buyer for X percent and hold their feet to the fire, you know, basically saying they want to work for free. You know, okay, so I had this in my notes. So worst case, if a buyer can't afford compensation and a seller is not offering compensation, does the buyer's agent send them to the listing agent without representation? I know we can negotiate compensation as part of the offer, but what if the seller is adamant about no buyer rep compensation?
I mean, it's going to be a difficult, awkward conversation. You know, I can't really sugarcoat that. But that's a conversation to have at the beginning of the relationship. You know, so everybody is understanding here's how compensation works. You know, you're professionals. This is not a hobby. You deserve to get paid for your efforts, and you should know what your value is, and you should know what your worth is. And so have that conversation. So, I mean, you say it's a worst case scenario. I don't really have a good answer for a worst case scenario.
Yeah.
It's going to be uncomfortable. So, you know, what do you do when someone wants representation, but they can't afford to pay it? That's a conversation to prep it. I mean, maybe the answer is, you know, maybe we need to look for another property.
And David, well, the one thing, and I'm sorry to cut you off, I kind of been thinking about this in a way that if they can't afford $1 million home, you know, because of financing purposes, you're not going to show them the $1 million home. You know, they're going to give you the range. This is what they can afford, et cetera. And so you can piggyback off of that and say, listen, you know, if you can't afford compensation that we agree on, that you are investing in me as your representation, you know, if the seller is completely unwilling, am I violating any fiduciary duty by saying you technically cannot afford this house because you cannot afford compensation?
I don't know if I would go so far as to say they can't afford the house. I don't know, Lori, do you have...
Sorry, I know that's tough, but Candy's brought it up in multiple classes, and it's basically if the seller is just obviously you're going to try to submit that offer and try to negotiate that compensation as part of the offer. Everything's negotiable, et cetera. But and again, no crystal balls, no nothing. It's just an interesting concept to think: do I say, hey, you can't afford my representation, so you should just go unrepresented, or
Right.
do we skip the house?
Right, I understand. And I think it's important to kind of back up, because I hear some chat, you know, see the chat talking about steering. We're definitely not talking about steering your client. You have the conversation about what the client can afford. You have the conversation about this is my fee, that, you know, and you negotiate what that fee is. And then you have the conversation about, well, there are listing brokers out there who might offer compensation. When we put in an offer, the seller might offer compensation, and then you need to come up with your own policies and kind of where's your own personal line. Like, well, okay, if there is no compensation and now you're working and there's nobody who has said that they're going to pay you, that's something I think on each brokerage you need to kind of figure out what's your line. What do you do? Do you need to terminate that relationship, that representation, because, you know, if they don't pay you, that would be a breach of your representation agreement.
Yep.
So at what point in time, you know, do you have to say, okay, I'm going to have to call it? But it's important to not filter anything from your client, not filter any information, not make these decisions for your client. So that's how we're avoiding any kind of, you know, steering going on. So give your client like all the properties that meet their criteria, you give it to them. Okay. And then you can, once you start making those calls and those texts and you figure out what compensation there is, you say, okay, here, you know, here's the compensation. And then you say, you tell me which ones you want to go see. You know, even if the listing broker is not offering compensation, there is still a possibility that once you put in the offer, the seller might agree to compensation through contract negotiations. And so you make sure you spell all this out. And again, you might have to have a conversation about, okay, worst case scenario, if you have your eye set on this property and there's no compensation from anywhere, you know, I work hard, I deserve to get paid. We might have to talk about, you know, how's that going to happen, and if we need to terminate this relationship. And is that going to be a hard, awkward conversation? Absolutely. And I'm, you know, knocking on wood. Hopefully that rarely happens to anybody. But yeah, you might run into some difficult conversations out there.
That's fair.
And I would add that, you know, scenario playing is helpful and interesting. It's challenging to talk about these things, but it's also going to be market driven. What's going on in your local market? Is it a seller's market? Is it a buyer's market? So I think the important takeaway from this conversation is our members are going to have to get comfortable with change. You talked about that earlier, but kind of reading the market, what's going on out there as they're having that conversation. We can't say right now exactly what the conversation is going to need to be with that buyer that may not be able to afford the commission. That may change over time with the changes in the market locally. So I'm hoping that the takeaway is getting a better understanding of your value, how to talk about your value, and how to ensure that you're in compliance while having a conversation with your buyer about what's being listed on the market, what's being offered in that assistance in paying broker fees.
So you're saying we need to get better at communication.
We are.
Communicate. Okay, so I'm the president of San Angelo Association of Realtors. We had an MLS meeting, and we had an interesting conversation about enforcement of the buyer rep rule. And that's one thing I haven't heard many people talk about is how do you prove that person A has been working or has that signed buyer rep agreement, and are local associations responsible for that policing, or is it broker to broker?
The requirement is an MLS rule. Okay. So it is at the hands of each MLS to enforce that rule. So they didn't really change the enforcement procedures. It's just, okay, here's now a new rule that you can use your normal, typical enforcement mechanisms. And so there's not just one way to do that. NAR has not mandated that, you know, the enforcement has to happen all this way. It's use all the available enforcement tools that they have. Will some MLSs, you know, be more proactive about it? You know, it's possible that they can start reaching out and saying, you know, doing like a quality check every so often, say, let's see your, you know, buyer representation agreement. They could do something similar, like with TREC, what they do with the IABS. You know, you have to give that first substantive communication. TREC is not demanding everybody send in their IABS, but if there's a complaint for something else, the first thing they're going to say is, let's see your IABS. Let me see to make sure you did it. And so they kind of tack it on to all the other complaints. So it's possible, you know, an MLS might do something along those lines. So it really is going to be a variety of different ways, but it's the MLSs are the ones who are in charge of enforcement.
So if I go show a house and the listing broker asks to see my buyer representation agreement, either before I show that house or before I send them an offer or whatever, what can I nicely say to them?
I mean, to me, the buyer representation agreement, all both sides, listing agreement, buyer rep, those are confidential.
Yep.
You know, that's between you and your client. You have no, business showing that, demanding to see somebody else's. So that kind of tongue in cheek. But if a listing broker asks me to see my buyer's rep, I say, well, let me see your listing agreement then. Don't do that. I was just kidding.
Well, David Jones said.
I also think there's also concern from the listing side that maybe they're supposed to make sure you have a written buyer's representation agreement, and there's no burden being put on the listing agents under the MLS rules. It is MLS enforcement. There's certainly the opportunity for a broker, if they think that there's a broker out there that's just not complying, to report that to the MLS. But there's no enforcement required by listing brokers to ensure that buyer's representation agreements are being used.
Yeah, the MLS, they're the ones who can, demand to see agreements as part of their enforcement authority. So, listing brokers, if you really feel that someone's not complying, the proper way to go is to file an MLS violation complaint, not demand to see somebody else's confidential documents.
Perfect.
Can we touch on real quick? I know we have a ton of forms. Exclusive right to sell, 1101. 5A, 5B is, I think, amazing in outlining exactly, what you're offering, what you're not offering, what the seller is and is not offering. But there has been some confusion. So obviously 5A is if they are willing to offer compensation to the other broker. 5B is if they are not. But then there's a reference to 1412, or I'm sorry, 11F, and then 1412. And I guess we may be overthinking 11F. And it's seller does or does not authorize broker to share with other brokers and prospective buyers that seller will consider contributing an amount towards buyer's expenses, such as buyer's broker's fees or other expenses. So if they are offering compensation in 5A, but say you are not authorized to advertise that, basically, or share it, I guess that's the big hang up, is everybody's going, well, wait, they're offering but not willing to tell, not willing to communicate.
Okay. Yeah, and we have gotten that question, and it does seem to be a bit confusing for members. And so we might update this, this agreement. Keep in mind, we made a lot of changes all at once, and so we are still getting, member feedback, member comments. So it is still subject to, for us to make some little tweaks here and there. But I see the confusion there. 5A is where that's like you're doing it now. Right. The seller pays the broker a fee, and part of that fee that they're paying is going to be shared. To advertise, that's different. That's the listing broker offering compensation. Okay. As opposed to if the seller is going to be open to, seller concessions or contributing to buyer's expenses, however you want to say it. Those are two different methods of compensation. The listing broker in 5A saying that they're going to offer compensation, you already have authority to advertise that. Okay. That's not a checkbox. That is already worked in, and it is down in paragraph 11 as well. Paragraph 11, by the way, is where the broker's authority, it's got a few bullet points under there that talks about what the broker is authorized to do. So it's already worked in. There's no checkbox. You have the authority to advertise, disclose offers of compensation from the listing broker. The new thing is if you use 5B and the seller is only agreeing to pay their own broker, well, now you're going to open up the possibility that buyers are going to request the seller, not the listing broker, the seller, to contribute towards their buyer's broker's fees or any other, buyer's expenses. And so now it becomes a question of, does the seller want you to disclose and advertise that? Not from the listing broker, but specifically that the seller is willing to offer concessions, or however you want to say it. So that's what 11F is. It is specifically about, from the seller, authorizing, the listing broker, do you want me to tell everybody that you're open to offering seller concessions? Because if we do that, all your offers are going to come in with seller concessions, so you want to make sure you get the specific authorization. So that's why we put 11F as something separate that's different than listing brokers offering compensation.
Okay, so if your seller agrees to 5A, right, do you need anything in 11F, or is 11F strictly for 5B?
Well, it's not strictly for 5B, because it is possible, we have to go with flexibility here, so we can't, just limit it. So it's possible for the listing broker to offer some, and for the seller to offer some as well. Maybe the seller and the listing broker to split it, half and half. I'll offer some, you offer some. So if it's possible for, if you use 5A and the listing brokers has the authority to advertise that the listing broker is offering compensation, it is still possible that the seller will authorize, okay, you can also tell them that I'm willing to contribute, some amount towards seller concessions.
But absolutely no bonuses, no compensation discussion in MLS.
Correct.
Also, I'm sorry to jump in, but remember that 11F in the form is not just for broker fees. It's for expenses that seller may be willing to cover on behalf of the buyer. So it's broader than broker fees.
Yeah, I think the confusion obviously is the comma such as buyer's broker's fees included in that paragraph. And so but that's why we're getting clarification.
Well, and remember that seller concessions, which we always use that phrase, but that's not actually a term that's in the TREC contracts. But paragraph 12 in the TREC contracts, where you're talking about the various expenses of the parties, and then there's a provision for what seller will pay to contribute to a buyer's expenses. That's been there for a very long time, but we never had that discussion in the listing agreement. So now we're putting that discussion in the listing agreement. I think that some MLSs are adding a field for an amount to go into the MLS that the seller would consider contributing up to this amount to pay buyer's expenses. Now, if it goes in the MLS, it cannot be tied to broker fees, but there can be an amount that the seller is willing to consider paying on behalf of buyer's expenses, and that can include broker fees. So we're taking an old concept of seller concessions, paragraph 12 in the TREC contract, and we're carefully adding into it the possibility for broker fees.
Gotcha. Yeah, I know our MLS has discussed doing a yes or no option and also a blank. I thought it'd be somewhat problematic to have a blank inputting there because everything is negotiable. And so your seller may wake up one day and go, I don't want to offer that.
Well, and that's a great point. Anything that goes in the MLS, anything that goes on form 1412, until there's negotiation between the buyer and the seller, it's not a done deal.
So there's a lot of talk in the chat about how this is going to affect appraisers and how we need to talk to the lenders about the different scenarios. I might joke a lot about appraisers just because Sterling and I have known each other a very long time, but I can't even imagine what this is going to look like for them moving forward, for lenders, for every part of the party. And we have to work together through this. We have to talk to each other, bridge that gap, as we all say, and make sure that we all work together for that end goal and not against each other. I think that is going to be even more important moving forward.
Well, and I'd hoped Candy Cook would be here because all appraiser questions should just go to Candy Cook.
I'm texting her as we're no. So someone asked if the seller will pay.
Yes, if seller will pay
buyer's commissions, where does it go on the 1 to 4 residential contract? If they will pay, if the seller will pay it directly, how do people put that into the contract?
So we created a new form. It's TXR 2406. That is intended to be, it is an addendum to the TREC contracts. We worked with TREC to make sure that it worked well with their contracts. I said earlier that if TREC updates their forms, it won't be for another 6 months or so. This 2406 can be used with the TREC 1 to 4 to add in that the seller will pay buyer broker's fees directly. That form also ensures that there's transparency. It talks about the other written compensation agreements that might be involved in the transaction, but it also creates a new obligation if the seller is paying buyer broker fees directly. That form can be used for that purpose.
Fantastic.
And I absolutely love the compensation agreement between brokers. It used to be called the registration agreement. I used it a lot in Farm and Ranch for at the time non-MLS participants, especially those that I didn't know. Sending that before, I really love that y'all shortened it to a 1 page, and I think it's extremely useful. And that would be 2402.
Hey, Sterling, can I make one comment about that? We only got a couple minutes. It's important to realize that 2402, the compensation agreement between brokers, that's basically the new agreement for brokers that replaces MLS offers of compensation. Okay, there's one big difference though. When the listing broker offer compensation through the MLS, that became a legally binding contract. Right. Even though nobody ever had to sign anything, just the way that the MLS worked, it was a legally binding contract. So now that offer of compensation is gone, now you need a contract to replace that. That is 2402 compensation agreement between brokers. But I want to make it clear, you have to sign that. Right. So we talked before about brokers putting compensation on their website. That's not legally binding yet. Right. So you can't just show it with your buyer, go through the deal and say, hey, where's my money? It's like, we didn't agree to money, but you put it on your website. Well, it doesn't work like the MLS anymore. So that's very, very important to understand. Just because you see a number, you hear a number, it's not binding until you sign a contract. So please make sure you understand you got to get something signed in writing between the listing broker, cooperating broker for that compensation agreement between brokers to be binding.
So yeah, so we had 16 we have 16 updated forms, 3 new forms. Is that correct?
That's right.
Yeah.
I encourage everybody to go read them. There was a lot of thought put into these. The new FSBO, the new representation, or all of these updated forms do a really, really good job of protecting us and protecting the consumer ultimately, and having written agreements for everything as suggested by both attorneys.
And I know a lot of people probably still have a lot of questions out there. Highly recommend get into a class. They are being taught all over all the time, and some of these questions are addressed there. The new forms and the updated forms, where can they find a list of those?
The updated and new forms are still on if you go to texasrealestate.com, not the blank forms page, but there's, I think, a general form page at the bottom. It has adopted forms, and that's where you can actually see the red lines.
Perfect.
These are already in zip forms, correct?
Mm-hmm.
Correct.
Yeah. You can also get to the adopted versions on the lawsuit webpage. We mentioned there, texasrealestate.com/lawsuit. There's a link to see the red line version of the forms is there.
Awesome.
All right. Our sponsor, Agent eLearning, has an offer for you that attended let me see if I can put it up there. Maybe not. There we go. 15% off your continuing education. Use code AEL15. We have about 30 seconds. Sterling, you want to take us out?
Yeah, no, David, Lori, thank you so much. Again, I know y'all are so busy. Thank you for discussing all of these issues with us. We didn't have one question where you said, I'm an attorney, I can't answer that. So I'm super happy about that. Again, just thank you so much.
You're welcome.
Thank you, everyone, for being here. We'll see y'all next time.
Bye, everyone.